All right, everyone. I think we'll go ahead and get started now. Thank you all very much for coming today to our Bench and Bar Committee Lunch and Learn presentation. I'm going to start. My name is Cece Schnapp. I am chair of the Bench and Bar Committee. I am law clerk to Chief Judge Mullins here at the Bankruptcy Court, and I am delighted to have you all here today with us. And for those that are on the phone, thank you for joining us as well. I'm going to give a few announcements, housekeeping matters before we get started. So first, we are broadcasting this on the phone and online, so I will do my best to speak up, but because of that, we can't have microphones that give feedback. So if you're in the back and want to come closer, please do so. Also on that note, the presentation will be recorded and it will be available about a week from today online on the court's website. The PowerPoint presentation that we are using today is also available currently online on the court's website. So if you want to follow along, you may do so there. And you can also download the materials after the presentation. I will definitely ask if you have questions, you can feel free to ask them, but we will have a point in the presentation when we will open up questions and then have another opportunity to do so at the end. I know you'll be eager to ask our great speakers and they'll be happy to address your questions, but please hold them until those points. And for those on the phone, we can take your questions at the end. I want to take a brief moment to thank those who made today possible, to Gail Goodman for all of her help in getting the logistics of this sorted out and for getting the CLE. If you would like credit for today for one general CLE hour, you may get that either today here by giving a check to Gail, or she will also accept checks for $5 made out to the State Bar on Wednesday. Find her downstairs on the 3rd floor. Also, big thanks to our IT department and our IT gurus for helping us set this up and set up the materials on the court's website, to the clerk's office for helping us work out the logistics, for our judges for supporting this program and coming here today, and for all of you for being here. So without further ado, I will introduce you to our wonderful panelists, and then we'll jump right in. So to my right, I have Sarah Bowling-Mancini, a staff attorney in the Home Defense Program of the Atlanta Legal Aid Society, and she is of counsel to the National Consumer Law Center. She graduated from Harvard Law School in 2007 and received a Skadden Fellowship for Public Interest Work. She clerked for the Honorable Amy Totenberg upstairs in the District Court for the Northern District of Georgia. She has advocated for vulnerable homeowners facing predatory mortgage lending practices and foreclosure in state court, federal court, and bankruptcy court. She complements individual client representation with media outreach and policy advocacy, and she is the author of several treatises. To her right, we have Matt Berry, founder and principal of Berry & Associates. His firm has specialized in consumer bankruptcy and consumer protection litigation for over 27 years. He has extensive experience in FDCPA, FCRA, and TCPA cases, and particularly as those claims relate to bankruptcy law. And finally, we have Guy Geppert, who was appointed by Attorney General Eric Holder as acting U.S. trustee for Region 21 in January 2013. That region includes Florida, Georgia, Puerto Rico, and the U.S. Virgin Islands. Guy previously served as assistant U.S. trustee in the Atlanta office and has participated in numerous working groups to implement the U.S. Trustees program. He has received the Director's Award for Exemplary Service for his longstanding contributions to the program. Before joining the U.S. Trustee program, he practiced law in Atlanta for 17 years. He received his undergraduate cum laude from the Illinois Wesleyan University, and after completing active duty in the U.S. Army, received his law degree from Vanderbilt University. So let's dive in. Of course, the usual disclaimers go. The opinions expressed here today are those of the panelists and should not necessarily be attributed to their employers. What are we going to talk about today? Well, we're going to give you a brief overview of the FDCPA, what it is, what the history of it is, and how it compares and contrasts to the Bankruptcy Code. Then I'm going to turn it over to Matt and Guy to talk about the filing of sale proof of claims in the recent Supreme Court Johnson case. Finally, we'll hear from Sarah about debt buyers and the issue that came up in the other recent Supreme Court case, Henson, about whether a debt purchaser qualifies as a debt collector under the Act. Here we go. The FDCPA, the Fair Debt Collections Practices Act, was enacted in 1977. Its purpose was to protect unsophisticated consumers from unscrupulous debt collectors. It does so by setting forth rules governing communications between debt collectors and consumer debtors. In essence, it regulates how debt collectors can interact with debtors. It prohibits the debt collectors from certain activities, namely from false, deceptive, or misleading representations, and from using any unfair or unconscionable means to collect or attempt to collect a debt. So what exactly that meant was that issue in the recent Johnson case. The Act also authorizes private lawsuits and weighty fines to deter bad practices. In enacting the Act, Congress noted that there was a lot of evidence of abusive, deceptive, and unfair debt collection practices. They found that these practices contributed to serious problems, including numerous personal bankruptcies, marital instability, loss of jobs, and invasion of privacy. So they basically sought to eliminate these by enacting the Act. As I said, the Act prohibits a number of different types of things and abusive acts. So, Matt, what exactly does the Act say is abusive?
Well, in terms of abuse, it's on a case-by-case basis. You've got harassing phone calls is what immediately comes to mind. And that's not necessarily in the context of bankruptcy, but it's not uncommon or was not uncommon before to have debt collectors that would call a consumer dozens of times a day. With the advent of robocalling and automated dialing systems, that became incredibly easy to do. And they would literally just harass these people until they got what they wanted, which was some sort of payment. Calling in the middle of the night or beyond certain hours, calling and discussing the nature of the call with third parties other than the consumer, they're also very common. So these are examples of what would be considered abusive. But there's really no limit to what could be considered abusive. It depends on the facts of the case.
Great. So what happens if a debt collector violates the Act and it engages in some sort of behavior that is not allowed? Well, a consumer there are a couple different routes. A consumer can file their own private right of action, and the FTC also is authorized to bring an enforcement action. So if a consumer is harassed at the hours outside of, I believe it's 8 a.m. or 9 p.m., for example, they can file a complaint with the Georgia Department of Law's Consumer Protection Unit and or the FTC's Consumer Response Center. And they can also sue the debt collector in state or federal court. Now, if the debt collector is an attorney, they can also contact the state bar about that behavior. To establish a violation, they need only show that the defendant falls under the Act, that they are a debt collector, and that the collector engaged in some sort of prohibited activity. They don't need to show any sort of willfulness. The debt collector, if they are found to have violated the Act, then could be liable for damages, including out-of-pocket expenses, damages for emotional distress, statutory damages, and fees and costs. There are, however, limits to the Act. It notably covers only consumer debt, so it covers any acts to collect personal credit card debts, auto loan debts, medical bills, and mortgages, debts of that sort. It does not cover commercial debts of any kind. So it won't cover any acts to collect a loan that was incurred to run a business. It also, claims are enforceable are only against debt collectors, so not to creditors. And this is an issue that Sarah will discuss in more detail later. I will note, though, that some states have their own enforcement laws that may be broader, and so they may cover the conduct of a creditor. For example, in California, I believe a creditor may be subject if they engage in the sort of behavior that is prohibited by the FDCPA. So basically, debt collectors can still contact consumers by phone, by email, by letter, by text to collect the debt as long as they follow these rules. I'll also note that the debt is still there. It's still valid debt. You may just have some sort of recourse for engaging in bad behavior. So how does the FDCPA interact with bankruptcy? Well, there are two different statutes, and creditor harassment can violate both the Act and the Code. So I'll give you a couple examples. These cases here are illustrative of how that works. In the Randolph case, a Seventh Circuit case from 2004, the debtor filed Chapter 13 bankruptcy. In the bankruptcy, the debtor included a debt owed to a dentist. 2 years after the debtor filed bankruptcy, when the case was still pending, the debt collector sought to collect that debt owing to the dentist. The debtor filed a suit in district court alleging violations of the FDCPA. The district court initially dismissed the case, finding that the code provided any sort of enforcement that the debtor could file for stay violations, file a complaint for stay violations and seek damages from the bankruptcy court. Well, on appeal, the Seventh Circuit, Judge Easterbrook disagreed. He found that there are simply different rules with different requirements of proof and different remedies. So the district court FDCPA suit could go forward, notwithstanding the bankruptcy. Similarly, in the Garfield versus Ocwen case out of the Second Circuit last year, the court found that there was no irreconcilable conflict between remedies under the code and the FDCPA. In that case, the debtor had again filed Chapter 13, and it had included mortgage arrears in their plan. After the case was completed and the debtor received a Chapter 13 discharge, the debt collector sought to collect not only payments that had become due post-discharge, but also the pre-petition mortgage arrears that were paid through the plan. Again, the debtor filed a district court action which was dismissed, and the Second Circuit found that that was wrong, but the debtor could proceed under both the FDCPA or under the code for a violation of the discharge injunction if they wanted to. And as Judge Easterbrook noted in the Randolph decision, there are a lot of differences between the Act and the Code. They have some overlap, but they're subject to different standards of liability and different recovery. So as I noted, the FDCPA is limited in that it applies only to the conduct of debt collectors. The Bankruptcy Code, anyone who violates either the stay or the discharge injunction could be subject. The standard necessary to prove the violation. In the Bankruptcy Code, you need to prove that a violation was willful. That means that you need to be able to establish that the actor had actual knowledge of the bankruptcy when they engaged in some sort of wrongful behavior. Under the FDCPA, that's not necessary. It's a lower standard. You just need to show, again, that a debt collector engaged in some sort of prohibited activity. Though the standard is lower, the potential damages are also lower. So you'll note that there is a cap to some recovery. The Act also deals with matters such as class actions, maximum recovery, attorney's fees, and a period of limitations, and the Code does not deal with such things. So a few things to keep in mind between how the two are similar, but again, they can coexist, and cases have definitely found that conduct can violate both. So with that overview, I'm going to turn it over to Matt and Guy to discuss some more particular aspects of the FDCPA and bankruptcy.
Move this down so we're right in between you guys, so the people on the phone can hear us. I think maybe guys up first. Here's your clicker. Yeah. Can I just slide that a little?
And I would ask that you just, if you have questions on this material, we'll have a chance to ask them after this presentation of this issue. So definitely we would love to hear from y'all. But please hold them just for the time being.
Thank you. I want to thank our wonderful clerk, Gina Thomas, for providing these statistics to us just to give you some idea of the problem. In calendar year 2062, 108,067 proofs of claim were filed in the Northern District of Georgia. Through June 2017, 55,405 were filed in the Northern District of Georgia. As I'm sure you know, many of us, most of us in this room probably have an obligation to review proofs of claim, and that would include reviewing them for things like, are they time barred? In a Chapter 13, the debtor's attorney, pursuant to General Order 18-2015 and the Rights and Responsibilities Statement, has a duty to review proofs of claim, and according to our handbook for Chapter 13 trustees and our handbook for Chapter 7 trustees, both our standing trustees and our panel trustees have an obligation to review proofs of claim and object, but there is a qualification there. The Chapter 7 trustees are to object if their objection to a proof of claim would be beneficial to the estate, would benefit creditors. What does that mean? Well, obviously, in a no-asset case, they're not going to object to a time-barred proof of claim. It would be pointless. With respect to others, an objection might not always benefit creditors. So there is not every time-barred proof of claim is going to be objected to by a trustee. Matt, would you like to talk about the cases leading up to Johnson?
Johnson was, the progenitor for Johnson was a case called Crawford. I'm sure most of you are familiar with Crawford. When the Crawford case came out, it also, like Johnson, originated from Alabama. And that was the original case that said, basically, the filing of a proof of claim in a bankruptcy case on a debt that would otherwise be time-barred is, on its face, deceptive and misleading and unfair, and thus a violation of the FDCPA. When the Crawford case was decided, my firm started filing FDCPA actions in district court and in bankruptcy court related to that cause of action. And to quote a colleague at Traub and Sanders who was defending LVNV, he referred to Crawford as an unfortunate piece of jurisprudence. I guess unfortunate depends on the side of the table you're on. I find that the Johnson case is much more unwelcome bit of jurisprudence. But in any case, in the Crawford case, the court left open the possibility that the issue of preclusion or preemption. And so that's what the Johnson case was based upon. And once it worked its way through the system, as well as the Supreme Court heard it and issued a decision this year. And what it basically said is that the filing of an accurate proof of claim that is otherwise time-barred is not unfair or deceptive or misleading. It was authored by Judge Souter, I believe. So that's where we are now. A proof of claim by itself, again, in my view, assuming it's accurate and complete, is not going to be a violation of the FDCPA simply because the debt would be time-barred under state law. But the key here, like everything else, is in the lead-up and the phrasing the court's used. For it not to be a violation, it has to be accurate. And in my view, for it to be accurate, it must be complete. So I would urge you that despite the overall holding in Johnson, that you review these proofs of claim that are time-barred in particular to make sure they are in fact accurate and not misleading. So when you look at the question of misleading, of course, now you have to look at misleading to whom. The FDCPA was designed, and the case law it's interpreted over the last 30 years, has basically said it should be viewed from the standpoint of the least sophisticated consumer. So not the most sophisticated, but the opposite, the least sophisticated. And most courts have resisted the temptation to input different types of personnel or personalities into that test. So in other words, if a correspondence was sent to a lawyer, some companies defended saying, well, it should be the least sophisticated lawyer test, and that was rejected for the most part. Although in the Johnson case, the Supreme Court did take note of the fact that the audience in a proof of claim is going to be the debtor's attorney and the trustee, neither of which are going to qualify as least sophisticated. The court overlooked or was unaware of the fact that part of that audience pool is, of course, the consumer himself or herself. But be that as it may, it appears that the Johnson case is leaning towards the audience of who's actually reviewing these proofs of claim, us and the trustee. So there again, now you have to look and see if the proof of claim is accurate, or if it's misleading, or if it's somehow deceptive. And if it is, in my view, nothing in the Johnson case precludes an FDCPA claim based on that proof of claim. Nothing in the opinion mentioned preclusion, certainly not preemption.
I just want to add, and I know, Guy, you're going to jump in here as well. Preemption was the language used in some of the early cases, and it's not a question of preemption because these are two federal laws. So
right.
Preclusion or implied repeal would be the issue.
And that created confusion everywhere because you had courts that were using preemption and preclusion interchangeably, sometimes in the same opinion.
Mm-hmm. Yeah.
So it caused a little bit more, again, unwelcome confusion. Mm-hmm. I'm not sure she's got to advance this through the arrow.
Yeah. Okay. That you may have already hit.
Okay, so this is just kind of facts of Johnson.
Oh, it's laptop. Okay, there we go.
Okay, there we go. 11th Circuit, I'm sorry, I should have, I guess, been clicking all along. The 11th Circuit reversed Johnson initially, and that's what took it up to the Supreme Court. 5-3 decision. This goes through the criteria. The court paused on the question of unfair, but eventually resolved it in favor of the collector in this instance. But again, it focuses on accurate. This first portion is also worth talking about briefly. When it defined a claim is important. Basically, the court said that under 105, even a debt that's not enforceable under state law is in fact a claim under the code. But it made mention of Wisconsin and Mississippi. Both of those states have statute of limitations laws that basically state there is no, this claim is not unenforceable in the statute of limitations, there is no claim. And we have a couple of those here in Georgia. The first thing that springs to mind is an auto repossession. If the repossessing entity does not comply with state law within certain time frames, specifically giving notice to the consumer of their intent to sell within 10 days of repossession, no deficiency claim arises. Can't be enforced in state court. If it can't be enforced in state court, if there is no claim, then there can't be a proof of claim here that's not violative of the FDCPA. Another example that we've litigated a good bit in the last year is you'll see a lot of debt buyers, if you go through these proofs of claim, are buying debts or claims based on payday lenders. Payday lending is illegal in Georgia. It can't be enforced. In fact, there's penalties that are pretty severe under state law. And the payday lending industry, despite the fact you won't see the storefronts like you do in Alabama or South Carolina, there's a lot of online payday lending. And we can go into that. That can be a whole day. But basically, you had a lot of deep-pocketed secondary banks that underwrote payday lending institutions based on Indian reservations, taking the position that they were not required to comply with any state law because they were independent nations. And there's several of those cases pending with the Attorney General here in Georgia. That argument has been stricken down everywhere. So good news for consumers there. But if you do see proofs of claim that carry lenders like Spot Loan or Sequoia Lending, I urge you to look them up and see who they are. If you don't recognize their name, it's worth checking them out.
Matt, let me take a swing at the softball you just pitched that you just threw up. So you're saying if you've got a claim for a debt of the kind you just described, it might be worth taking another shot?
Oh, absolutely. And I'm going to show you a proof of claim in a few minutes that I think is violative of the Act, and we'll look at it together.
Okay, do you want to run us through what the government had argued here in Johnson?
Yes, I will. Thank you. Matt touched on some of the arguments that were made in this Midland Funding Johnson. We in our program we call it Midland, not Johnson. So if I confuse you, I'm sorry. The government filed an amicus, and signing on to the Solicitor General's brief were the Consumer Financial Protection Bureau and the Executive Office of United States Trustees. That's us, me. And we, I thought it was a real good brief, but the court apparently was not persuaded. Our basic argument, we argued, as you can see, that the Fair Debt Collection Practices Act bars debt collectors from using the judicial process in bankruptcy to collect a time-barred debt. The court found no congressional intent to use the Fair Debt Collection Practices Act to address bankruptcy questions, bankruptcy-related questions. When we argued, and I'm going to read this because the solicitor took and we took a strong position. We said that the filing of a time-barred claim reflects, and I'm quoting, reflects a calculated effort to exploit the imperfection of the Code's disallowance mechanisms and to prevent the claims allowance process from functioning as Congress intended. The court did not agree and said there was nothing misleading, deceptive, or unfair in asserting the right to payment by filing proof of claim subject to the claim's disallowance process. We argued that tried to use in our argument that the trying to collect time-barred debt would be subject to Rule 11 sanctions, and because such an attempt would be subject to Rule 9011 sanctions, that the act itself was unfair and misleading. The court touched on that and made the following comment about Rule 9011, noting that one court has held that filing a time-barred proof of claim without a pre-filing investigation merited sanctions, but noted that other courts had held to the contrary. It did not. The court did not address the line of cases, not more than just one, that we cited in the solicitor's brief, which found that filing a proof of claim of that nature without investigation violated Rule 9011. We argue that on 9011, on its face, the rule demands that a plaintiff through counsel must undertake a reasonable inquiry into whether any claims she plans to assert in federal court are supported by non-frivolous legal arguments. The court did not agree. We also tried to argue, did argue that claim means a claim that is not stale. The court did not agree with us. The Supreme Court said that the Bankruptcy Code employs an expansive definition of the term claim, and then went on to comment about the effective process for claims disallowance. Talking about the expansive process for claims disallowance, the court essentially said, no harm, no foul. Knowledgeable trustees, debtors' attorneys, others can object to claims. We talked about the effect that time-barred proofs of claim have on the court, eating up judicial resources. We talked about the burden on the trustees as well. We've been making that argument for several years now. Finally, the court...
Yes. This is worth looking at a little bit, because you can see what the Supreme Court is doing is looking at the mechanisms for claim disallowance and saying, well, that's more than sufficient, assuming that's actually what happens. And of course it's not. The debt buying industry, if you don't know this, is a $1 billion industry. And their business model does not have them reviewing the accounts, find the proof of claim, receiving the objection, reviewing it again, sending counsel downtown to argue it. Their business model consists of the immediate withdrawal of any claim objected to, instantly. So the court never sees these things. You know, the trustee's office does, we do. Their business model is not to advance valid or even arguable proofs of claim. It's simply to flood the system with proofs of claim and see what gets objected to.
I'll give you some numbers about that a little later in our talk today. Yes, Bob.
Say that, Matt. It makes one think that you ought to object to every claim filed by the debt-buying vultures, but if you want to just do it without yourself feeling confident that it's time.
No, I mean, our duty is higher. We need to review the proof of claim, and if it appears to be valid on its face, then we don't object.
Yeah.
So and often we'll see, you know, in the, I mean, I'm sure you did the same way, when we assemble a petition, we're using the client's shoebox full of records, and we're also pulling the credit report and looking for any gaps. And if there's any doubt at all, of course, we schedule it. Well, those records would easily include debts that would otherwise be time-barred or invalid. We don't know that at that time.
Why don't we go ahead, I think, and
Okay.
yeah, we have a couple of examples of proof of claims that I think may still be problematic given this recent decision. So if we put forward a couple, we'll see.
Okay. Let me wrap that up and give you some numbers, and we'll look at. Can we then look at the slides? Okay. Finally, our last slide here. The court said that the bankruptcy code does not altogether displace the Fair Debt Collection Practices Act. It creates a delicate balance between the two, and if they said that if they found that the act would be applicable to the analysis of stale debt, it would upset the delicate balance. That is a bit of a difficult argument to explain, but and I would have to direct you to the decision. But we are left with a so where are we slide. I want to note it's very important the court was not called upon and did not address ongoing litigation in which the U.S. trustee asserts that the intentional filing of a large volume of stale debt claims is an abusive process. The court did describe the bankruptcy process and the expectation that trustees would object to the claims. Certainly, this practice harms legitimate creditors, debtors, and the court. I'm limited to what I can say about pending litigation, but I said I would share some numbers to you. In a case pending in the Western District of Missouri, we allege that one claim filer filed 142,804 time-barred proofs of claim with a face value of more than $260 million, on which it had collected more than $12 million as of March 2016. And that's where we are. The problem continues to be out there even after Johnson v. Midland, and it's something that everybody is going to have to address. And now, if we can look at those examples.
Okay, this just reiterates what we just all talked about. Okay, I'm going to have to move around here a little bit so I can see this and point this out to you. This is a claim we have pending now in our office, or a case we think. The Chapter 13, I honestly don't recall the things in front of me. I don't think it has. This was filed based on a telecommunications debt. You can see it here, instant communications. And this is the attachment, the account detail provided by the creditor. Okay, so you have the account number, the debt to insure, amount due as a bankruptcy, principal, interest, fees, charge off by the creditor with 8/12/2011. Last payment date, last transaction date are both blank. So how is Marietta or Nancy or Adam or me supposed to figure out when the statute of limitations runs on this? unless you have this, the last payment date, there's no way you can calculate it. You can make a pretty good guess it's running, but you don't know. So this date here, this date field is critical to the analysis. All right, now just to jump forward, I love that. This is the service contract, and I hardly ever see these attached to a proof of claim, but this was kind of a bonus. The service at a glance just shows actually that the amount was credited to the debtor back in. An outright lie in communication, the omission of information that is otherwise necessary to make it truthful is itself misleading or deceptive. This is on the form because we need it. We have to have it to do the analysis. So that's one example.
Great.
So yeah, it comes up.
Yeah. Well, thanks on that part. And thanks all on the phone for bearing with us there for a moment. We got disconnected, but Matt was running us through the analysis of some potentially problematic proof of claims here.
At the end of it?
That is.
Okay.
We want to pause for a minute and just see if anybody had any other questions or comments about the sale proof of claim issues before we move on and talk about debt buyers and the Henson case.
I was going to ask if you feel during the course of your Chapter 13 case that your client now has an FDCPA cause of action. Do you typically amend your schedule? Does that come into a calculation by the trustee of what percentage you have to repay to unsecured? Find yourself with equitable estoppel issues if you don't do that, and the case is over.
I think you have to disclose the asset. In our office, we amend Schedules B and if it's appropriate, Schedule C. And then we usually will file a motion to be appointed for that purpose, although in some of the courts we have here, that's not necessary. It's obviously part and parcel of the case, and we file the adversary.
But are you also saying amend Schedule F to take the claim off, or
no,
not necessarily? You're not worried about that listing?
If you damages, it may affect
You're talking about exempting
the liquidation
Yeah.
test on
So-
percentages.
Yeah.
The question for those on the phone was, what happens if during the course of a bankruptcy you find that you have an FDCPA claim? Do you go ahead and amend the schedules, or what do you do then?
And we do. We amend the schedules appropriately, and then we bring the action. And where we bring the action just depends. If it's a proof of claim action, we're probably going to bring that in bankruptcy court as an adversary for a couple of reasons. Number one, you're saving your client or the estate the $4 filing fee that should be otherwise charged in district court. Secondly, anytime the district court sees the word bankruptcy anywhere in the document, they get really upset.
As we saw in the cases.
Send it back here.
Yeah.
So most of the cases we're going to bring that fashion, we're going to bring as an adversary case in the bankruptcy case.
In addition to service by U.S. mail and
oh yeah, there's a lot
of
of
great
reasons to stay here.
Great. Well, we'll keep going, and we'll save some time for questions at the end about all of these things, and we would love to hear from folks in the room and on the phone about your thoughts on these issues. But let's talk briefly about debt buyers. And so part of our goal here is to kind of give you the hot topics of what's going on with FDCPA litigation and as it touches on the bankruptcy practice that folks have. So the other, in addition to the Midland versus Johnson case, the other really recent case from the Supreme Court is Henson versus Santander. So I'm going to speak briefly about that and of course, welcome any of you to join at any point if you want to add anything. The decision was authored by Justice Gorsuch, our newest Supreme Court Justice, and I will describe it as a little bit zingy. I think that he really enjoyed writing this opinion, and he did write for a unanimous bench. the holding essentially was that Santander, who was a debt buyer in this instance, was not covered under the definition of a debt collector for purposes of the FDCPA in order to be covered by the FDCPA, because as Cece mentioned at the beginning, you have to be covered by the definition of a debt collector in order to be sued under the FDCPA. However, as I'm going to discuss in a bit more detail, there are two prongs to the definition of debt collector, and the court really only looked at the second prong and said that it was not met here in this instance. So let's just talk briefly about the facts. These plaintiffs had gotten car loans from City Financial Auto, and when they defaulted, City Financial repossessed the vehicles, sold them, and Santander was originally acting as a servicer on behalf of the creditor, City Financial. So I think that's an important fact of the Supreme Court that Justice Gorsuch really glossed over, is that Santander did buy these debts, but it was after having acted as a servicer, a debt collector, for a while. So that's interesting. And another part of the background here is that there was a settlement agreement in which City Financial waived the right to collect any deficiency balance. Then Santander bought the debts and attempted to collect the deficiency that had been waived. So that was the basis of the FDCPA claim against Santander that was based on misrepresentation of the amount owed and the authority to collect the debt. So here is the definition of a debt collector, and it's in 15 U.S.C. 1692A sub 6. And it says a debt collector is any person who uses an instrumentality of interstate commerce in the mail. This is the first prong. In any business where the principal purpose is collection of debts, or, here's the second way, any person who regularly collects or attempts to collect, directly or indirectly, debts owed or due or asserted to be owed or due another. So option one is principal purpose is debt collection. Option two is you regularly collect debts that are owed or due another. So it's important to note that the Supreme Court did not address the first option, the principal purpose debt collector definition. And in fact, it had been raised below, but the Supreme Court kind of acted like the argument had not really been made or fleshed out. The District Court and the Fourth Circuit had both looked at it and concluded that Santander was not a principal purpose debt collector, and noted that Santander noted that it does originate loans. They claimed their principal purpose was loan origination. So this principal purpose definition is going to be different depending on who your debt buyer is. And so it'll be a lot easier if you have an instance where you have a debt buyer who does not originate any loans and really principally does debt collection. But again, the Supreme Court sort of opted not to look at this prong and really only looked at the second prong. So, and in looking at the second prong, the Supreme Court really, I didn't put it in the slides, but essentially just said, looking at the language here, we find that Santander, because they own the debt, they are not collecting debts that were owed or due another. And there were some arguments about the verb tense or the tense of owed, whether that was meant to be past tense, but the court didn't buy it and said essentially if you are the owner of the debt, you're not going to fit under that prong. And this is going to have a big impact on, as Matt mentioned, a huge multi-million-dollar industry of debt buyers that are in some instances collecting for another and then buying a debt, and they seem to now have a way to absolve themselves of FDCPA liability. So I think the important thing coming out of Henson is that there may still be a way to bring FDCPA claims against debt buyers, but you've got to be able to focus on that first prong of the definition that the Supreme Court did not address, and that is, can you argue, can you plead facts showing that this is an entity whose principal purpose is debt collection? And you do want to make sure that you plead facts to support that under, an Iqbal-Twombly standard. And I've given you a couple citations here to cases. So of course, my recommendation is that if you have cases that are pending now against debt buyers, that you move to amend if you need to add factual allegations that will get you into that first prong of the definition. Again, this is for debt buyers. If you have entities that are collecting debts that are owed or due to another, then you're okay. But it's really going to be an issue for these debt buyers.
And look at the proof of claim. And that sounds painfully obvious, but look and see who signed it. Now, just because the debt is owned by Santander, that doesn't mean he has to fill the proof of claim out. Often you'll see third parties that are actually facilitating the proof of claim filing, and that entity is almost certainly going to be part of the FDCPA. If you looked at that proof of claim you put on the screen a while ago, you probably couldn't see it, but LVNB is the owner of the debt. Well, if you recall in the earlier slides that CC had put up that showed the differences between the code and the act, one is that class actions are limited in FDCPAs to, I think it's whatever.
There's a cap.
Yeah,
There's a certain
one of the caps is $500,000 or 1% of the value of the defendant, whichever is less. Well, so all these major debt buyers, they have collection agencies that are captive or that are subsidiaries, and that's who's collecting the debt. LVNB's never filed a proof of claim, but Resurgence Capital has filed tens of thousands, if not hundreds of thousands, and so is Pinnacle, and so is all these other little entities. So when you look at the debt buyer, just because you see that LVNB is owning the debt, don't let that be an immediate turn-off to your claim. Keep going through the proof of claim and see who actually filed it.
I would note also that one reason that this has become such an issue, and that the Supreme Court noted a little bit in both decisions, but especially in the Henson decision, is that the market for defaulted debt has changed so much since, remember, the Act came about in 1977. So a lot has changed, and it has become much more complex, as Matt and Sarah have both noted, in that time frame. So that's why kind of who really falls into this category of debt collectors can be so tricky.
And if you bring these actions, you better believe it makes a difference. When Crawford was decided, my firm filed a lot of these cases. But the number, we read the proofs of claim every month, the number of out-of-statute claims plummeted immediately in the 11th Circuit. And in every circuit where Crawford was picked up and carried forward, you saw the debt buyers immediately stop filing proofs of claim. Well, I can already tell you that's already cranking right back up again. This is a July proof of claim, and there's several like it.
Our director has also noted that there are more stale claims filed in districts where trustees do not routinely object to stale claims than in others. So this all, not to be parochial, but if we want to stop the practice here, if we would all become more diligent at objecting to stale claims, it would it might chase them into another district.
And I know 9011 is a pain in the neck to use because you've got to give them notice, and you're going to spend more time giving them notice than you would objecting to proof of claim. But don't overlook 105. And I have not done this yet, and who knows how it will be received. But if you can bring an action under 105 and say, this is on the Smith case, but here's the last 30 proofs of claim that I had to object to. This is pattern and practice evidence that this particular creditor or collector or debt buyer is abusing the system and abusing the court.
And when the court in Johnson v. Midland talked about, or Midland v. Johnson talked about 9011, they were talking about one claim. They were not talking about a systemic pattern, a systemic business practice, business model that we've described here. And if you want to read a great description of the debt collection industry, read Justice Sotomayor's dissent in the Johnson case. It's outstanding.
Let me take just a minute, and I'm not sure how familiar you are with the FDCPA, so indulge me if you already know this. But I know that your time, my time, all of our time is at a premium. You're always competing with everything else you have to do regarding the work. If you find an FDCPA claim, the FDCPA claim or act has fee shifting. It's automatic. It's not discretionary. If they're in violation and the statutory penalty is $1, fee shifting is complete. You start working on your fee application. And the creditor bar understands that very well.
Really good argument for looking into these claims. And bankruptcy practitioners really probably would see a lot of these violations if we are looking for them. And I know we want to open it up for questions. I'll just say one more thing, and then we'll take your question. I did want to mention mortgage servicers, too, because that's my world that I mostly practice in. In the Home Defense Program of Atlanta Legal Aid, we mostly handle bankruptcy cases where there is a mortgage at issue. So just be aware, mortgage servicers are collecting debts that are owed or due another. There is a carve-out if they became the servicer of a debt when the debt was current, but as long as the debt was already in default when they became the servicer, they are covered by the FDCPA. And many times with mortgage servicers, there is a change of servicing after the loan is in default. There are specialized default servicers. And these days, servicing is transferred so often anyway, it's very likely you have a covered party. And then also the law firms that collect on behalf of the mortgage servicers are debt collectors. The foreclosing law firms are debt collectors covered by the FDCPA. So just be aware that those claims still exist. And I did want to mention that the National Consumer Law Center has a bunch of resources on these issues. Of course, we put out the yellow consumer manuals that look like little phone books, and those are available online now in a very easy, searchable format. And they also have a website specifically dedicated to materials, sample briefs, and pleadings following Henson, and an email address to send decisions to. So I just wanted to mention that. There was a question in the back, and we'll repeat it after you speak.
Like crossing around Johnson. We just want to kind of pretend that Johnson didn't happen. And we just want to keep going with these FDCPA in different exceptions. So, Johnson actually said that the affirmative defense approach took care of that, and that they weren't going to fall down. And it seems like there are burdens now. There's always been there, but there's burdens on the trustees, procedural rules, the debtor's attorney, to actually look and file objections to the claims to resolve the issue. And I can see where a debtor's attorney would not want to use legal money to save costs, because they would never get the money that they're seeking out of the FDCPA causes of action, because the creditor is simply this claim and satisfy the state claim. So I'm hearing from a panel of more on the debtor's attorney side. I'm not hearing the actual addressing of the distinction. Okay? I want to kind of work around that decision and continue the problem.
I'm going to try to restate it really quickly. The question was essentially, are we ignoring Johnson? Johnson says what it says. It seems to be a major bar to some of these claims and to be redirecting the bar to other methods. Do you want to?
No, I think we're working within Johnson. I mean, at least in my office, if Johnson had been decided the other way, we'd go back to filing 20 or 30 of these cases a month. What we're looking for now is inaccuracy in the proof of claim, something that is going to have the potential to deceive the audience, the trustee or me.
Why doesn't you come to the claim that the debtor wants because you're charging debt?
Well, the objection to the claim will get rid of the claim, but that doesn't mean there's not an FDCPA violation.
Then you notice that I'm not going to address Johnson.
Well, I don't think that the court used the phrase accurate proof of claim, without knowing what it was saying. I think the word accurate has meaning there.
So I think our position is that although the court circumscribed these claims somewhat, they did not eliminate them from the bankruptcy universe.
If I remember, I didn't write this down, I probably should have. If I recall, the author of the opinion simply said a claim that is accurate on its face is not misleading. Mm-hmm. So if that's true, and obviously it is, then a claim that is not accurate is misleading.
I would also note, there may be other ways also. That's just one issue, right, that came up in Johnson, the stale proof claims. There may be other conduct that violates either the code or the FDCPA. I think, we'll take another question.
Henson now, that used to sort of push the business model in the collection agency world to turn basically everything into debt buying, perhaps even with a funding structure modeling like like that. People own them, they don't really own them. Well, have you seen any of that either from the USOC side or obviously if you're going to have on the better path? So when you kind of have a chance again, what's the way to do that?
And there's certainly companies out there that are big enough to do that, PRA, and, I'm sorry. The question, as I understand it, is, have we seen a push yet or a change in the industry whereby the the debt buyers are collecting in their own name from that point going forward and putting themselves outside the reach of Henson. I think that's going to be problematic and not a simple solution for them because they still can't get past their principal purpose. The principal purpose for a lot of these companies is simply the acquisition of debt and the collection of it. Santander is very different. Santander is primarily an auto finance company, an auto servicing company. And you'll have that in some instances, especially in the mortgage industry. There are several mortgage companies that are both originators and servicers. So you can see that being an issue you've got to deal with.
But there are more and more servicers that are not banks and not lenders too, so watch out for those non-bank servicers, Ceteris, Carrington, SPS, FLS. There are a bunch of them. It used to be that the banks made up the largest chunk, but it's less so now.
And there's always more of those, by the way. I mean, every month has new mortgage servicers entering the market and mortgage servicers leaving.
I think that that's a good question and a good note for us to wrap on is that, these issues will continue even though we just had these two big cases come out. So on that, I would just like to thank you all again for coming, and please feel free to look at the court's website for these materials. And please join me in thanking the rest of our panelists.